Involvement with the criminal justice system is life-changing. It matters.
Having a justice system that works is a really important part of a democratic society.
I'm Penelope Gibbs, Director of Transform Justice.
I'm Rob Allen. I've worked in and around criminal justice all my career.
This is the Transform Justice podcast, throwing light on the criminal justice system.
Hearing from people who know.
It's about whether the system's fair
and what can be done to make it better.
Hello. In English and Welsh courts, are children accused of crime treated fairly? To discuss this, I'm joined by my co-presenter Rob Allen and by two experts on child defendants. Aika Stephenson is a solicitor and author of In Your Defence, Fighting for Your Justice One Child at a Time. Danielle Manson is a barrister at Matrix Chambers. Rob, can you just give us a kind of primer on how children are dealt with in the criminal courts in England and Wales?
Well, children as young as 10 can be prosecuted, which is a very young age compared to most countries. Most who are arrested are dealt with outside the court by the police or by youth offending teams. Where they do go to court, most are dealt with in the youth courts, where specially trained magistrates hear the cases. They're supposed to be less formal than adult courts and have a wider range of sentencing options. But in serious cases, children can be tried in the Crown Court. And while the process there is supposed to be adapted to meet their needs, that's proved pretty hard to achieve in practice.
Aika, let's start at the beginning. Do we prosecute the right children, or are there cases which get into court which really shouldn't have got there?
Yes, a significant proportion of the cases that are in courts I actually think shouldn't be there. Lots of them could have been diverted or dealt with differently. And a lot of the reasons behind why children end up in the criminal courts are things that could have been looked at earlier. So often it's things like learning difficulties that haven't been diagnosed in secondary education, which have then led to exclusion.
But can you give us an example of the kind of crimes you just think this shouldn't be in the youth court?
There are kind of two tranches of cases. So there are cases that are simply ridiculous. So general, what would be considered as playful or mischievous behaviour ending up in the criminal court. So I've had a case of a young person who was messing about on the top of a school bus and threw an empty plastic bottle at a child and was prosecuted through the criminal court for common assault. That case went all the way to trial. He was acquitted at trial, and the magistrates obviously expressed their concern as to how he'd got there, but it should never have been there in the first place, and he should never have been made to go through that process. And then you have lots of children who you can see that there's been a history of them being failed by other institutions, and you think they just shouldn't be at court, because if people had intervened earlier, then they wouldn't be there.
You spent, Danielle, some time observing the courts in the USA. What most struck you as different about the way they treat child defendants? Because, you know, obviously USA has a reputation for being very punitive, and they do prosecute relatively young children there.
Well, there are a couple of things. I think firstly, in the US, they don't make findings of guilt. They make findings of involvement. So they are factually finding that, yes, this child did engage in that conduct, but they're really mindful of labels. I think this is really forward thinking, because to put a label on a child, as you say, as young as 10 or 11 in this country, to say you are guilty, it's got really negative connotations. And language matters, you know, when we're dealing with children and young people. Labels stick with them. And so for me, the finding of involvement was really, really important. Another thing I noticed was the way the building was designed. On the floor, as you walked into one of the courts that I visited, they had lots of really positive statements engraved in stone on the floor. And it was just a little thing, but it was actually trying to make that building a place of rehabilitation, or a place where positives could come from it, because the court estate in this country is in a really, really disgusting state at the minute. The courts are dilapidated, there's been no care put in, and they're designed in a certain way to be intimidating and to make people feel uncomfortable when they're there. And I understand that that's their purpose. But when you're looking at children, I think perhaps a slightly different approach should be taken to make the space feel a little bit more comfortable for them. But what actually happens is these kids are just shoehorned into a magistrate's court building.
I mean, Aika, thinking about what actually happens within the courtrooms, I mean, ours is obviously an adversarial system fundamentally for children as well as adults. In your book, you describe it as being a bit like a theatre or a battle. What do you mean by that? And why is that bad for children?
Well, I think one of my clients captured the essence of the problem really when she turned around and said to me, the prosecutor hates me. I know she does. She hates me. And I think that is everything that
and
is wrong
did you know what she
with
meant?
the system. Yes.
Was it very aggressive questioning?
Well, it wasn't even questioning. It was simply an argument as to where the case would be dealt with. So the case summary is prepared by the police officer, and that case summary is often just read out by the prosecutor. They don't take the time to look at what they're actually saying in open court. They certainly don't think about the way that's going to be received by the child that's present. Obviously, the whole setup in the court is adversarial. So, the prosecutor sits on one side, the defence lawyer sits on the other side. If you're lucky, then you might be able to have your client next to you or near you, but it's not always the case because the courts aren't always set up that way. And they very much see the prosecutor as somebody who is against them.
Danielle, does that ring bells with your experience in the courts?
I think so, and I think particularly in the youth courts, what you get a lot of the time are in-house CPS prosecutors. So they are employed by the Crown Prosecution Service, and all they do day in, day out is prosecute. It's almost like a factory process. When I go in representing a child, it doesn't feel like they're at all focused on the individual at the centre of the case. They're just going through the motions because it's what they do all day, every day. There's no variation. Whereas what you have in the Crown Court generally are barristers who sometimes prosecute and sometimes defend. And for me, I've noticed quite a big difference between the approach that is taken by the in-house CPS lawyers or advocates and members of the independent bar. I'm a member of the independent bar, but I only defend, so I only ever see it from the defendant's perspective. And I know from my own experience that, of course, that informs how I approach a case. So I can see why children would walk into that space and feel an air of hostility directed towards them because the people who are there representing the state only ever represent the state. They never see it from the defence side. So although I appreciate that the in-house CPS prosecutors will have undertaken specialist training in order to prosecute young people, they're trained to prosecute.
So hence the theatre, the battle.
Yeah.
But what I would say is, irrespective of which side you're on, so to speak, the CPS have endorsed a child-first approach, and they do need to take a step back and think about the approach that they take in court. It doesn't need to be the way it is. Without even changing the adversarial system, there is a way that they can approach it. And there is a way of conveying information in court so that it doesn't appear to be so personal towards the child that is present.
Yeah. So, I mean, is it about the language they use, the way they speak to the young people, trying to avoid technical language, that kind of thing? Is this what the child-first approach means, or is it more than that?
Yeah, it's a lot more than that. But I think in terms of the CPS, the focus should be on rehabilitation and lack of criminalisation. I mean, it's about that young person being able to feel like the court process has been fair to some degree. And I think that the current way that it's approached, that young people don't feel that way. There's no sense of fairness or even processes being adapted so that they can understand what's going on.
I mean, an example of a case that we both worked on was a case where a young person within the youth justice system had been charged with, I think, 25 counts of very low-level sexual assault. So this was touching the thighs of his classmates over their trousers, grabbing girls. And he was facing a trial in the youth court. Aika and I went through a very long, stressful process of making written representations to the CPS that dealt with the youth court. And we hit a brick wall time after time, and they were saying, no, he must be prosecuted, even though he had a lot going on in his personal life. What then happened was that he turned 18, and because of a technical legal provision, we were able to get him into the Crown Court system. And as soon as we got into the Crown Court system, we resent our letter of representations, and someone in the Crown Court team completely understood what we were saying, that this was a disproportionate prosecution. It wasn't in the public interest. Yes, he may have behaved inappropriately, but it was a very long time ago when there was a lot going on in his life. And actually, what he really needed was to go on a course about, appropriate behaviour when it comes to how you treat females, not given a conviction. And they dropped all 25 charges. And that only happened because he turned 18 and we were able to get him into the adult Crown Court system.
But, Aika, it's always said that this youth court, which is the kind of magistrates' court but for children, is more child-friendly than the Crown Court. Is it in some ways more child-friendly?
It depends which court you go to.
Yeah.
There are still quite a few courts where the magistrates sit much higher up than the children, and that in itself can be quite intimidating. There are other courts where everyone is on the same level, and so you're able to sort of establish more of a conversation. And the approach taken by magistrates can be really varied. I have clients who might walk into court and for their own kind of protection, they'll have their hood up. They are really struggling to sort of engage with the process, particularly clients who are neurodiverse, and they often find it difficult to relax in that setting. And immediately they'll be greeted with, take your hood off, take your hat off, take your do-rag off, sit down.
Take your hands out of your pocket.
Yeah, you need to respect this court, you need to respect this process. And obviously, I think young people are very clear that respect should be earned. And the way they're treated just from walking through the door, when it's something that most of the time they're really quite scared about and worried about and anxious about, they can be greeted in that way, which obviously sets the whole proceedings off on the wrong foot.
And that can be the chair of the bench, the lead magistrate. You write in your book that you wince sometimes when you hear some of the things that they say, for example, asking if they're sorry and that kind of thing. Why do you think they do that? Do you think they're trying to engage and do the right thing? Or
Yeah, and again, it's very varied. We all as practitioners know there are some district judges who are amazing in terms of the way that they choose to engage with young people, and magistrates who kind of set the tone in their courtroom in the most child-friendly way. So I don't want to criticise everybody. But yes, I've, recently made submissions on behalf of a client who was autistic, and it was very hard for him to express remorse. It was very hard for him to express anything in relation to feelings. And I thought I'd got through to them, and the first question, they got him to stand up in the middle of the courtroom and said, well, what have you got to say to us? Do you feel sorry? And he couldn't articulate what he felt.
And did that have an adverse consequence for him? Was it interpreted as being, well, he's not sorry, therefore?
Well, I then raised, they've actually asked him the one question it was most unlikely for him to answer, and that there were potentially other questions that they could raise that he might be able to engage with, but.
But irrespective of the question that they're asking, when we are in the Crown Court and we're swearing a jury in, when those 12 members of the public are asked to take an oath or affirmation, and all they're being asked to do is read off a laminated piece of paper, the amount of times that these ordinary people stumble over those words or mispronounce something or have to be asked to repeat it because they've not said the correct word, that for me really exemplifies how intimidating it is for people to speak in the courtroom setting. If jurors can't do it by simply reading, I don't know why we expect our children to be able to do it and to show insight into offending behaviour. Also that a bench of magistrates can tick a box and say, yes, he's shown insight.
So when you're in the youth court or the Crown Court, what is the kind of behaviour from judges or magistrates which makes you think, oh, I wish they didn't?
Well, asking them, how do you feel about what you've done, or who do you think your offending impacted? almost sort of guilt tripping them. I've also had some quite clumsy observations about the fact that there was a trial in the first place. So obviously in a criminal case, if you plead guilty, you get credit, which is basically a discount off your sentence, and you save the court time and everyone's very pleased that you've pleaded guilty. But I feel like in the youth court, in fact, I had an experience of it today where even though it was the right of the defendant to have a trial, it's almost used against them when it comes to sentence. And there are comments made about the fact that, well, you didn't accept that you did this and we had to have a trial.
And you've wasted our time.
And you've wasted our time. And I think that's highly inappropriate. But I think the impact on a child of saying that is much more pronounced, isn't it? Because you're effectively saying to the child, you're a liar, even though it's their right to have a trial. And even though sometimes you're having a trial not factually on whether something did or didn't happen, but whether that amounts to an offence. So they're fully entitled to have that aired in a criminal court, but they are sometimes, in my experience, berated for even having the trial in the first place.
I mean, Aika, one of the aspects of unfairness that you write about in your book is to do with race and the overrepresentation of black and minority ethnic children right through the justice system. What are your particular concerns about what happens once these cases get to court?
I think frequently you see the approach that is taken particularly to black boys. You see that they aren't seen as vulnerable by the courts. It feels like there's an assumption of guilt sometimes, and also an assumption that they'll be fine on remand. They're not afforded the same level of innocence as white children.
When you say fine on remand, there's a sort of feeling that they'll cope okay if we send them to
they
custody.
See, there's been a lot of talk in the press and in academia about the notion of adultification, and that's the process by which black children are seen as less vulnerable, more, naughty. How that plays out in a courtroom is just not being able to see that young person with all of their vulnerabilities. So looking at their physical appearance and literally believing the stereotype that this child is stronger, that this child is less likely to not be able to cope in that environment, and essentially that having an impact on the bail decision. Also thinking that child is older than they are, has more understanding. The term that's been used is streetwise. They're much more streetwise.
And it's not just a lack of seeing them as vulnerable, but it's then buying into stereotypes and sort of perceiving them to be scary. Black men are generally perceived as being scary. And so when you're dealing with black boys, exactly like Aika said, they're not seen with any innocence. They're seen as aggressive and scary. The rest of society needs protecting from them, as opposed to looking at what protections they need because they've fallen through the net previously.
I can give an example. We were approached by the head teacher of a secondary school who was very concerned to hear that two of her really bright students who were going off to university had been arrested over the summer between leaving school and starting university, and they had both gone to a festival and had both taken drugs with them that they were then supplying socially to their peer group to kind of fund their weekend. One of the children was white, the other one was black. The head teacher had come to know that they'd both been charged and appeared in court, and that the white child had been given a community order and the black child had been given a 3-year custodial sentence. She was really alarmed. She, in fact, stated very clearly that actually the black child would have had significantly more mitigation on his behalf than the white child. She couldn't believe it. But what it allowed us to do was actually take a case to the Court of Appeal, which had a direct comparative. And so the family of the white child had heard about this. They allowed us access to his case papers so that we could very clearly make the direct comparison. We took the case to the Court of Appeal, and It was Anya Lewis KC who made the submissions to the Court of Appeal, where she very clearly made submissions around race, and she was able to quote the Lammy Review at that time. It had recently come out, so that shows you sort of how long ago it was. And the Court of Appeal, whilst they didn't criticise the decision as racist, what they did say was that it was very, very clear that the Crown Court at the time hadn't paid due regard to the particular mitigating characteristics of our client. And so it was very clearly saying that his personal background hadn't been taken into account. They amended the sentence so that he was going to be released a short time after the appeal hearing.
But what you have now actually in some specific offences in the guidelines that the Sentencing Council put together is a recognition that there is a disparity in the outcome of sentences that are imposed on black people as compared to white people and other ethnicities. And I've been called bold by several judges because I will cite those provisions to judges when I'm doing mitigation, either in the youth court or in the adult court, but effectively saying to the court, you need to recognise that there is a risk of unconscious bias here.
Or conscious bias, for that matter.
Conscious or unconscious, I think the outcome's the same for the client. They get harsher sentences.
But have things started to get better on this front? I mean, you mentioned the Lammy Review, you mentioned the Sentencing Council. No. Things aren't going in the right direction.
No, because the nature of racism today, it's so insidious. You can't put your finger on it. And exactly like Aika said, that example of the Court of Appeal, they will never come out and say the reason that happened was because of race. And so having it in the Sentencing Council guidance is really helpful, actually, because it gives me a legitimate submission that I can make that is not me being political, it's not me being a liberal lefty lawyer, it's me applying legal guidance and saying to the court, well, have you thought about this? It won't change until you have a more diverse judiciary. And I mean the magistrates, district judges and Crown Court judges.
Yeah. I mean, looking a bit more widely, you both defend children in the youth court and in the Crown Court. I mean, would you prefer it to have a system in which all child cases were dealt with in a youth court, maybe a reinforced youth court?
Well, not in the current youth court, not in a youth court that's been shoehorned into a summary justice model.
What do you mean by that?
So summary justice is a focus on getting cases dealt with quickly. And don't get me wrong, there is a public interest in that, both for victims and for defendants. It doesn't serve anyone to be waiting 3 or 4 years for the resolution of your case. But in my opinion, the summary justice model is often at the expense of the issue being properly litigated. And so with children, what you often have are very serious charges, rape, GBH, being dealt with in a summary way.
You mean too quickly, without enough time spent on evidence and cross-examination and so on?
Yes, and I'll tell you what happens is you go along to the first ever hearing for a case and you're presented with what's called a PET form, preparation for an effective trial form. And there, all the witnesses that are going to come for the trial are listed. And at that very first appearance, you as the lawyer have to write down how many minutes you're going to spend cross-examining each witness. And the court will then give a rough time estimate based on that. Fast forward to the trial, if you end up cross-examining that witness for 40 minutes, 50 minutes, the magistrates or the judge will say, well, Miss Manson, you only put 30 minutes down on the PET form. You've been double that.
Even in the youth court?
Even in the youth court, even if you're dealing with a rape case, because in their mind, the priority is to keep the trial within the 1 day or 2 day that's been allocated for it. Whereas in the Crown Court, there is a recognition that sometimes a witness takes longer than you thought. But I've felt so much pressure in the youth court to finish things quickly, not necessarily to finish things properly. And I think that's unacceptable.
But in very serious cases like the ones you've described, Is it open to you to ask for a case to go to the Crown Court?
You don't have any of those options if you're a youth. You stay where you are told. And I can tell you that the only cases that go to the Crown Court are murders. The youth court will keep everything else.
Aika, what do you feel? You've worked in both.
Yeah, is the current system fit at all? That is one question. I think what we're constantly trying to do is make small improvements to a system that is essentially broken. And so we say, we could do this slightly better, or you could be more child-friendly in this way. But essentially, it is broken.
And it isn't child-friendly in either place.
No.
It's not child-friendly in either place, but you definitely, I think, have a better overall experience in the Crown Court. It's more scary and it's more serious. But there is something about being in the Crown Court where there's just a recognition that this criminal trial is the most important thing. Whereas in the youth court, you feel like they need to rush because they've got other important things that they need to get to as well. The other thing that is highly problematic in the youth court is that the youth court is not a court of record. So there is no recording of what takes place. So in the Crown Court, there is a system called DARTS where there is an audio recording made of what's taking place, and you can listen back to the audio recording or you can get a transcript. We don't have anything like that in the youth court. The only thing that you get is a handwritten note that is sometimes made by the legal advisor or the court clerk. Their notes aren't always either very good or even available. And so if you have a dispute about something that was said, or if you want to make a legal argument based on a particular phrase, there is absolutely no way for you to evidence that it was ever said.
So what happens if you want to appeal a case?
It's like any appeal from the magistrate to the Crown. You rerun the whole thing again.
But you wouldn't... So say, for example, you're saying, well, the witness in the youth court was lying. You wouldn't be able to put to them, well, in the youth court, you said that the car was red, and now you're in the Crown Court, you're saying the car was blue. You don't have that option. And I can only think it's because the governments of the day that we've had don't want to invest financially in putting the DART system into the youth court.
I mean, there's lots of systems they could use, I think. Just to focus again on the Crown Court, a kind of signal case in Crown Court history was that of Robert Thompson and John Venables, who were convicted of the murder of James Bulger. After that case, lawyers fought tooth and nail to establish that the court process that happened was unfair. Aika, what did they criticise about how Thompson and Venables were dealt with?
The biggest criticism was that the children were not able to effectively participate in the court process. So they had very little understanding of what happened in court. It was quite clear that they weren't following proceedings.
Were they in the dock?
Yes. I believe at times they were allowed to come out and sit next to social workers, and they gave them colouring pencils, or, ad hoc measures were taken. But after Venables and Thompson, various measures were put in place to make the Crown Court a more child-friendly place, that barristers shouldn't be wearing wigs, that children should be allowed to sit next to their lawyer. But at that time, it wasn't part of the criminal procedure rules in the way that it is now. And even now, you can still see that the practice direction is not being followed. So time and time again, you'll ask for barristers not to be wearing wigs, or for the application to be made to the court, to the judge. Some barristers are reluctant to make it, or when they do, the judge has very much said, well, they're streetwise, they're robust enough to have got involved in this offence, therefore I'm sure that they can manage with us wearing wigs. And children are frequently placed in the dock.
And I think the chances of you seeing a 10-year-old in the court are quite low. But what we're talking about is that in between, that 14 to 18, where they are still children. They don't always have the requisite understanding. A lot of them haven't been in a formal education provision. A lot of them have got undiagnosed learning difficulties or neurological or developmental conditions. I would like to think that now, if you did have a 10-year-old, that special dispensation would be made. But we have these problems with 16-year-olds. but they're not seen by the court as being children. And that's actually the problem. That's the bigger problem. And again, this is a problem between the youth court and the Crown Court, that in the youth court you will often get lawyers who don't specialise in representing children, and so they don't focus on things like that.
But I did represent 2 10-year-olds at the police station last year, and for both of them I couldn't even get them to understand the caution. And not unsurprisingly, I'm a skilled specialist youth lawyer, and I had to think of an analogy that my 12-year-old might understand about not helping the police officer with his homework in order to get them to understand just that simple concept.
They didn't charge them, did they?
No.
Oh, well done.
Not yet. One's still pending.
Oh, God.
Okay, well, it's fascinating and a rather troubling discussion, but we're going to have to sadly bring it to a close. We end these episodes by asking each of our guests, if they were in a position to do so, what one change would you make to the system to improve, in this case, courts for child defendants? It's a big ask, but if there was one thing. Danielle, let's start with you.
That's really hard. I think I've already touched on it. I think I would remove the youth court from the summary justice model. So I would like to see something that's more aligned with the case management that we have in the Crown Court, the amount of time and care that goes into listing cases, and, you know, obviously a little bit more money is probably what's needed to make that happen. But for me, having a youth court as an extension of summary justice doesn't work.
How about you, Aika?
I would like any child that appears in court and admits their guilt at that first hearing to then be taken out of the court process and dealt with some kind of out-of-court disposal or an early intervention approach by the Youth Justice Service.
Penelope, what would you do?
I mean, we haven't mentioned this, but I would change the age of criminal responsibility.
Oh, yeah, of course.
So at the moment, you know, a child can get into court at 10 and does. And so I would raise it to minimum 14, I'd say, as other Western European countries do. What about you, Rob?
I think we really need to look at the whole shooting match here and see whether the youth court and the Crown Court, as they're currently organised, are doing a good enough job, and fashion something that provides the right safeguards for children so they're not convicted if they haven't done anything wrong, but also is able to provide a kind of constructive sentence or disposal for the cases. It's not really working in that way at the moment and needs to.
Fantastic. Thanks, Rob, Aika and Danielle. And if you'd like details of Aika's book, the charity she works for, Just for Kids Law, and about children in the courts, do look at our programme notes. Until next time, bye.